Ladies and gentlemen, if you could take your seats, that would be very nice. And we'll start the next session. Do take your places. Coffee will come eventually, but you've just got to go through this session, so be brave. Well, welcome to this very important panel. Holocaust restitution is not really about money, it's about victims. It's about individuals who have waited for the best part of 80 years for justice and recognition of the theft of their property. Now, we know one or two things about the Nazis. We know that they were murderers, we know that they were psychopaths, they were bigots, they were racists, and they were anti-Semites. But to this list, they were also thieves. They looted and plundered throughout Europe. They stole from citizens, they stole from the states, and because there is no honor among thieves, they stole from each other. Wiesel pointed this out far more eloquently than me when he said that this was part of a process. He said this: they stole your living, they stole your belongings, they stole your individuality, and they tried to wipe you out, to wipe out the fact that you ever existed. It's been 13 years since 47 countries signed a Terezín Declaration in June 2009. 47 countries pledged to bring measures to fight economic wrongs that accompanied the Holocaust against Jews and other victims of the Nazi persecution throughout Europe. There's been progress. We heard about it this morning. Many countries, nations have adopted a special approach to enact specific measures to provide restitution or compensation for confiscated assets. However, many families across the world are still fighting to get restitution. Today, we should not forget the approximately, it's just slightly over 3 million Jews who lived in Poland prior to the Second World War, the vast majority of whom were murdered during the Holocaust. Our dear friends in Poland have done many fine things in terms of remembering the Holocaust, but they have not, with much sadness, they have not addressed the concerns of dispossessed Holocaust survivors and their heirs, nor have they addressed the return of property taken from non-Jewish Poles. Time is running out. We have a moral obligation to ensure the Holocaust survivors and their families receive justice. Now, we have collected for you this afternoon a stellar cast for this panel. We haven't got with us Anna Lessing, who very sadly, a friend to many of us, is not terribly well. However, we have got Pierre Schölnberger, who is a leading expert on art and art restitution, and we'll be hearing from her in a moment. We've got David Swan, from the Minister of Culture in France. We've got Ferdinand Trauttmansdorff, a former Austrian ambassador to Prague, and you heard this morning of his important knowledge in this subject. We have Anne Weber from Looted Art of Europe. We have Wesley Fisher, Director of Research, Conference on Jewish Material Claims Against Germany. Now, initially, and it will be a short presentation from each, I've asked them to address on the initial focus on key issues. Now, Wesley, I'd ask you to start, please. You just press the microphone. Press the microphone, and we should it will be on in a second. Yes. doesn't appear to be on the screens yet. I'm sorry about this. There we are. We're on. We're on.
So, I just want to raise 5 major issues in regard to looted art. We are going back and forth in regard to movable property and immovable property. But these are issues that still remain at this point that are, in some cases, rather important. So the first one, there's a relative lack of attention in Holocaust studies on the theft as opposed to the murder. If you look at what is taught in universities and in schools and so forth, obviously there is an emphasis on the genocide in terms of the killing of people. But in fact, there is also this important issue of theft. And it's a question also that the theft tends to accompany genocides generally. It's not just the Holocaust. So there's an importance here of using looted cultural property for Holocaust education as the survivor generation is passing. The fact is that we still will have these art issues with us. It's not just art, but I hope you realize that looted art in this case refers also to primarily books and Judaica, and it's the case. In many countries, the history of cultural property plunder by the Nazis, their allies and collaborators, is simply not known. IRA, the International Holocaust Remembrance Alliance, as a policy matter, ignores this part of the history of the Holocaust. Individual countries can bring it up if they wish, but otherwise it is not part of the discussion. A second general issue. There's an issue of art that was looted in other countries, elsewhere, that was brought into given countries. This happens in various forms. It happened through the Nazi art market. At the time, it happened after the war because of the changes in borders. It happened through the art market, happens through the art market since the war, including to the present day. It happens because of the Soviet trophy brigades as a general policy matter of how things were taken to the Soviet Union, as a result of mistakes and policies in repatriation by the Western allies as well. So we'll go into examples and so forth later, but this is a general problem. Moving on, there's a continuing problem of lack of archival access. This may seem to have been solved in many respects, but in this particular area, it has not been. And so there's an emphasis, or there's an importance of digitization and making the archives cross-searchable. There is an issue of how to handle communal cultural property. That is to say, property that did not belong to individuals, but belonged to and still belongs, in many respects, to the communities from which they came. There are 2 types of property in this regard: property that's in textual form, such as pinkasim, such as registers, birth, marriage, death registers, and other sorts of texts. And then there are 3-dimensional objects, such as ritual Judaica and the like. This is another matter. Lastly, in this list of 5 issues, there remains a question of how to handle those items which are still unclaimed, even after provenance research. Those items which may be stated to be, quote, airless. This refers to paintings, but it's also true of other cultural property. And you'll notice that I put on the end here an example of this. This is a photograph from an exhibition in the Netherlands that was done of such, quote, unclaimed, airless, looted art. And there are young people looking at this. So we'll come back to that. Thank you.
Thank you very much. That's a great start. If you just hand the clicker to David.
David.
Thank you. I will say also a few words about the main issues. I'm the head of the Office for Research and Restitution in the Ministry of Culture in France, working closely together with our committee, the CIVS, the Commission for Compensation of Victims of Spoliation, whose director is here too. I think one of the main issues, of course, it's obvious, is the provenance research, the need of provenance research, of course, in our collections, in public collections. And for instance, we have a lot to do, and we are beginning to work, just only beginning now to work on the public collections, not only some of the objects of dubious provenance brought back from Germany after the war, but the whole collections, all the objects which have been bought or received in a gift in the museum since 1933 should be checked if the provenance has gaps in between 33 and 45. So that's really a new challenge for all the museums here in France and everywhere. We have a lot to do, but also the art market has a lot to do. Ambassador Eisenstadt this morning mentioned the efforts of Sotheby's and Christie's, but even these major auction houses have a lot to do more, and all the actors on the art market have to work on this. Maybe another issue, but I will go very fast because it's not new, but it's not settled, and it is evaluating. It's maybe the definition of spoliation. We know what is looting, what is robbery, what is theft, but the definition of sale under duress is always evolving. Maybe in a good way, we see a more favorable approach to the families, to the victims, and that's the work of the committees, the Austrian one, the French one, to evaluate what is spoliation. Maybe, of course, it was also mentioned this morning, the third issue for us and for colleagues would be the legal issue. You may know that in France it's not very easy to return artworks which belong to the public collection, national or local authority collections. We used to return some particular objects brought back from Germany, but the objects which belong to the collections cannot be returned without a law. And the first law was voted this year in February, anonymously, we have to mention it, by the two assemblies in France, for 15 objects, but 15 specific objects, among them two famous ones, painting by Klimt and a painting by Chagall. And you can see also the owners, Nora Stiesny, who was murdered with her son Otto during, she was from Vienna in 1942, and David Sender in Poland. He survived the ghetto of Lodz and the camp of Auschwitz, but his wife and his daughter were murdered. So these objects belong they belonged in the past to the French collections, and they are now returned. But the main issue now is the next step is the deaccessioning law, long awaited, and it's the Minister of Culture announced that we are working on this, and there will be a special law. And maybe, but it was already said by Wesley, the question of the access to the archives is of course very important, and we can also announce that the archives of the Ministry of Foreign Affairs will be online in a couple of years, max 3 years. We have just only technical problems, but the will to publish it online is real. Thank you.
Thank you very much indeed.
Thank you, everybody. Despite the Terezín Declaration of 2009, the restitution of artworks that were looted often seems as distant a prospect as ever. Although many artworks since 2009 have been identified and returned, many thousands have not. Some 90% of all artworks being sought today by families have been neither found nor returned. Only 1/3 of countries have implemented any of the commitments made at Terezín. The pace of progress is often hardly visible, though the need to provide justice, is of course urgent. Achievement can be measured by the three central elements of the Washington Principles and the Terezín Declaration: it's provenance research and its publication, access to records and information, which you've heard about from David and Wesley, and fair and just claims processes or laws. The implementation of all three is essential for restitution to happen. Without provenance research and its publication, victims can't find their looted art. Without access to records and archives, they can't find the evidence of what was taken. Without equitable claims processes, families can't obtain restitution. So looking at the first one, provenance research and its publication, only 17 of the 47 countries that signed the Terezín Declaration have done any provenance research, and often to a limited degree. Frequently forgotten is that its only purpose is to enable the identification of looted art. So where research has been done, publication should not be delayed, as it often is, till the research on each artwork is completed. In general, all that is required initially in every country is for every object with a gap in its provenance between 1933 and 1945 to be identified and published. As most collections, public collections, are neither catalogued nor online, unless this is done, looted artworks within them cannot be found. Where research has been published, it is often to varying standards and levels of accessibility. Frequently, it is in online locations that are hard to find, in languages that families don't speak, in databases that are not searchable by normal search engines. It is also generally impossible to know what research has been undertaken in any country or when new information is published. And few countries, as a matter of course, proactively seek out the owners of artworks that have been identified as looted, which of course should be integral to the process. Looking at the second point, which are access to records and information, post-war claims records from Germany, Austria, and the occupied countries of Europe, together with Nazi-era records, are one of the major sources of information and evidence on what was taken. But till now, with only a handful of partial exceptions, claims records are not indexed by name, family name, and subject, nor digitized and made available on the internet. A major project is underway in Germany to digitize all their records, but this is going to take some years. In the meantime, undertaking this kind of cataloguing by name and by subject of file and providing finding aids based on that are essential, so that it is possible to know now where important records exist. In the current situation, what happens, families have to scour maybe 24 archives to find the records that are relevant to their case, and then they might not find all of them. Art trade records, dealer records are equally essential sources of evidence, and though a few more are available today than there were 20 years ago, the majority of art trade records are not accessible or available. This needs, I believe, a commitment by governments to work with the art trade in order to enable access. And thirdly, and obviously centrally, fair and just claims processes or laws. Still today, there are only 5 national claims processes, no more than there were 20 years ago, although it's one of the central planks of the Washington Principles. There are still only 4 countries with restitution laws. In the majority of countries, there is no clear route to restitution. So justice is still like a game of roulette, depending on the accident of where a looted work of art has come to rest. Mostly it's the current possessor of a looted artwork who is both judge and jury, deciding whether restitution should occur. Claimants are not equal parties in that decision-making process. Although transparency is a principle of justice, most countries have no claims process, no information about how a claim will be handled, what evidence is needed, the grounds on which a claim will be assessed. There are no standard definitions internationally, whether of loss, forced sale, or sale under duress, though these are included in the Terezín Declaration. Existing laws, such as statutes of limitations, which Ambassador Eisenstadt referred to this morning, so-called good faith acquisitions or export restrictions, may be used to impede restitution. Even national claims processes or restitution laws may prevent restitution, because legitimate claimants may be excluded from the law or the claims process. Lastly, the situation in the art trade and with private foundations and collectors remains largely outside any framework of understanding in all countries. Reaching any solution to a claim depends entirely on the attitude of the individual auction house or dealer or the private owner, and that is often negative, as there is no legal obligation on a private owner or trade or dealer to resolve a claim.
Thank you very much indeed, Anne. Ferdinand, would you care to address?
May I suggest that she speaks first, Mr. Schölnberger?
We are nothing if not a democracy. Pierre, would you care to address the meeting? That would be just lovely.
Yes, of course. Thank you very much to be able to be here and speaking for Hannah Lessing and also for myself for the Austrian Commission of Provenance Research. Given the fact that the other speakers were talking about Nazi-looted art, I would also like to start with this part about Austria and then to move on to the address by Hannah Lessing, if this is okay. So with the art restitution law passed in 1998, Austria has established an art restitution system that is, so some would say, probably unique in the world. At the federal level, the art restitution framework is based on several pillars. First, which is very important for us, it's the proactive and systematic research in Austrian federal museums by independent provenance researchers within the Austrian Commission for Provenance Research, which I have the honor to be heading. Secondly, it's the assessment of the findings of the Commission by the Art Restitution Advisory Board and the making of non-binding recommendations. Thirdly, the decision of the responsible minister, usually on the basis of the recommendations by the board. And if the decision is restitution, the next step would be the search for heirs, today carried out by the Vienna Jewish community. And as a last step, of course, the actual in rem restitution. So up to today, we have in 99 sessions by the board gave more than 375 opinions, of which 320 opinions were positive, which meant restitution of objects from federal Austrian museums, which led to the fact that Austria has up to now restituted more than 10,000 paintings, drawings, objects of folkloristic art, also natural history museums, objects or technical instruments and different other objects, and more than 50,000 books, especially from the National Library. So the present-day Austrian authorities are making efforts to assume responsibility for past injuries, but art restitution always remains and is regarded merely as a symbolic act. So I would like to continue with the address by Hannah Lessing, for Secretary General of the National Fund of the Republic of Austria for victims of the National Socialism. After the so-called Anschluss of Austria to the German Reich in March 1938, all kinds of assets, among them also immovable property, was seized from the racially or politically persecuted owners through various avenues. Although the majority of the seized properties were restituted after the war or were the subjects of settlements, the restitution proceedings of the 1940s, 50s, and 60s were and are considered unsatisfactory and fragmentary. So in 2001, with the conclusion of the Washington Agreement between the United States and Austria, a decisive step was taken in addressing injustices from the time of the Holocaust, aiming to close the gaps and remedy the deficiencies in the historical restitution and compensation measures. Many of the measures for Nazi victims provided for in this agreement were or are implemented by the National Fund, the General Settlement Fund, and the Fund for the Restoration of Jewish Cemeteries in Austria. One step taken in 2001 was an amendment to the National Fund law providing compensation for seized tenancy rights, household effects, and personal valuables. In total, about 175 million euros were disbursed in the form of lump sum payments to compensate these losses. The creation of the General Settlement Fund in the same year was intended to provide a comprehensive solution to open questions of compensation for losses and damages inflicted on victims of the Nazi regime due to events that occurred on the territory of the present-day Republic of Austria between 1938 and 1945. The General Settlement Fund comprised two decision-making bodies, each with its own procedure. An independent, internationally staffed claims committee could award compensation for individual losses and damage which had not or not adequately been dealt with by previous Austrian restitution or compensation measures. The ex gratia payments for asset losses in 10 different categories, such as liquidated companies, professional and occupational losses, or insurance policies, were an expression of Austria's moral responsibility. The amounts awarded were based on the individually determined asset losses, and payments were made in proportion to the total amount available. The Claims Committee decided on more than 20,000 applications containing approximately 150,000 individual claims. Some 25,000 Nazi victims or their heirs received compensation payments totaling around $215 million. In addition, an arbitration panel for in-rem restitution comprising 3 eminent jurists could recommend the restitution of real estate, superstructures, and
Pierre, if you could just...
Okay, and the movable assets of Jewish communal organizations if they had been seized. So, in cases where a claim of restitution, maybe I will pass the extreme injustice topic over to Ambassador Trauttmansdorff, and I'll come to the end because I think it's important to point out that in 2017, coming to an end, the European Shoah Legacy Institute published a comparative study prepared by independent experts on the restitution of private, communal, and heirless real estate in different European countries. Regarding Austria, the results of this study document and summarize the numerous measures implementing the restitution of seized private, communal, and heirless property in Austria, finally closing long-standing gaps and remedying deficiencies. In April 22, the General Settlement Fund, having completed its task, was formally dissolved by resolution of the Board of Trustees, bringing to an end one of Austria's most large-scale projects to provide compensation and restitution for victims of the Nazis. Thank you.
Thank you very much, and I'm really sorry to interrupt, but I'm trying to get everybody in and to cover all that we want to cover. Ferdinand, I think you wanted to address us?
Thank you very much. I try to be shorter. So, first of all, I was witness to 2 things which I want to highlight here. One is the progress that has been made in Austria was not there from the beginning. It happened very late. And I very well remember all the defensive attitudes which we faced in public, but also in administration against any kind of the up again the restitution, which was, in their opinion, so well done after the end of the Second World War. No, it was not well done. We found out that a lot of these restitution activities under the 7 restitution laws have been riddled by injustice and even extreme injustice, and therefore I want to quickly refer to this kind of this expression, which and legal element, which was part of the judicial activities of the Austrian arbitration panel, and which took care of the fact that after the war, many victims who tried to get their lost property restituted faced a lot of impediments to get their restitution actually done in full, and or even in an adequate manner. And this very often amounted to extreme injustice. Therefore, based on the Washington Agreement, and I will come back to that, this extreme injustice element was important to reopen cases that have been legally already closed beforehand. This is a concept. This could be further developed. It has been done by this arbitration panel, and there is a jurisdiction on which one can base future action. The second thing I want to highlight is actually that the progress in Austria would not have been made if we wouldn't have had a partner, a state partner, and the state partner was the United States, and with under the aegis of, as we know, of Stuart Eisenstadt, and we are eternally grateful to you and to your support and actually skills in handling this defensive attitude that was still existing in Austria at that time. This defensive attitude is of course not only in Austria. It happens, and we know all, in many other countries where there are still gaps and deficiencies of implementing the goals and objectives of the Terezín Declaration. And that we probably have to understand that in some countries, public ownership is conceived as the only way of national sort of having ownership with national identity. And restitution to private persons, particularly when they are abroad, is very often considered as being against national pride. Therefore, and this is also particularly in artworks, you see this attitude. But this attitude has to be dealt with, I think, in a constructive manner, and also taken seriously, because let's not forget, countries that have been occupied by Nazis, everything has been taken away, and then of course then their national identity came back after the end of the Second World War, and of course they wanted to live their identity, and this was in the way very often of constructive solutions, and it is until today. And therefore I think I'm very afraid that we leave this great conference, and I really thank again our Czech friends that they organized such a conference again after the Terezín conference, that we leave it without a follow-up process. And that's my other experience was the ESLI, the European Shoah Legacy Institute, which we hoped will make sure that there is an efficient follow-up to the Terezín Declaration. We have to admit it was not the case, despite all the efforts which Thomas is nodding, despite all the efforts which we invested here as friends of the ESLI. And therefore I think we need new approaches, and probably the best approach in dealing particularly with immovable property, heirless property, communal property and private property is, just one sentence, is actually a follow-up process which could be taken care of by the Holocaust representatives, or a number of Holocaust representatives who establish a network and a model on how to more effectively deal with the open issues that are still available in the countries. I can come back to that if there is time.
Well, thank you. And I'm very grateful to the panel for laying out the problem so succinctly and so clearly. But we mustn't forget that each home, each business, each piece of art has a human face. And I thought it might be interesting to actually hear from a victim. And I'd like to share a short film about the struggle of one man, Leo Wiener from London, who alongside his father tried to get the property back since 1946 to no avail. All 23 properties are in Ostravia, which is just a short car ride away from this very building.
Is Leopold Wiener. I was born in Ostrava Svino on the 11th of August 1932. I'm just about a month past 90 years of age. I came from a very big family, many of whom were engaged in commercial enterprises. When I returned to Ostrava, and one of the people who lived there took me on a tour, and I started pinpointing all these buildings. And the more I saw, the more angry I got. And I asked myself, how can this be? It's a moral obligation. I can't tell you how strongly I feel. Even if I don't get a penny of that money, although would have a good use for it, even though I don't get a penny of it, I would still want that money to be compensated by the Czech government on behalf of all those who perish.
I grew up hearing the history. I probably know it better than he does, to be honest with you. And I would say there's definitely a sense of intergenerational trauma, what has happened. So I have grown up experiencing a sense of loss and a sense of that, suffering and missing out, definitely.
Compensation for property, I think, would represent both an acknowledgement but also a validation of what my father's been through, both as a Czech citizen and also as a Czech Jew. And I think for us as a family, it represents such a lot in what's been a very painful but also very loving relationship. He's always spoken with such pride about being Czech. We've always been very firmly aware where he came from, what it meant to him, where his heart was, where his parents, his grandparents, always this big thing about what was then Czechoslovakia and what it represented. So I think the idea of compensation for the property wouldn't just be the physicality of what it represents, but it would also be a sort of emotional form of closure and resolution, and also as an act of healing, a very, very important gesture.
It's a healing process. It is to heal my grandfather of a lot of resentment, anger, and pain. That's what it is. It's a healing process. It's resolve.
That's absolutely right.
In view of the long relationship that the Czech people had with their Jewish community, it existed long before the Holocaust, long before all the upheavals and the pain of recent history. I think it would be very appropriate and very apt to realize the connection, to realize the bond that actually existed in those people who were thrown out of their homes and then forced not just to flee Nazi persecution, but forced because of circumstances to start a new life abroad from their homeland. I think the message would be to realize what it means to those survivors and their families to have some sort of recognition for what they've been to, and to acknowledge that it's a painful history lesson, but it's also still an ongoing relationship. And it's something to cherish and to value. When you have a relationship, you make amends.
I've kept the Czech passport because nobody can say I'm not Czech. But it's not just that. I've got the literature to prove it. I've got my birth certificate. I've got my current valid passport, Czech passport. I've got my family tree, which shows that we go back at least 200 years in the country. It's my country. They should pay me, they shouldn't cheat me and rob me. That's all I can say.
We saw briefly Josh, the grandson of Leo, and Josh is here. I think it might be nice just to hear a few words from him. Come on up.
Thank you, Lord Pickles.
You press that button.
Thank you, Lord Pickles. I attended this conference as an ambassador for my grandfather, who fled Czechoslovakia in 1939 as a 7-year-old refugee, preceding the murder of 70 of his family members in various concentration camps. As you can see in the video, my grandfather has never given up. He views it as his duty to his murdered relatives who perished in the Nazi death camps to bring some sort of closure for himself and maybe economic justice via restitution. As his grandson, I have witnessed a lifetime of trauma which stems from his young days and has carried into his old age. We seek recognition, we seek closure, not just for ourselves, but for all refugees and Holocaust survivors. I hope by being here I can make not only my grandfather proud, but also my fellow Jewish descendants of refugees and survivors as well from across Europe. This conference presents an amazing opportunity for you to bring some closure and peace to a lifetime of angst and pain for many of us. I'd like to leave you with a quote from Proverbs. When justice is done, it is a joy to the righteous. Thank you.
It's now appropriate for us to start to look in terms of the individuals. And Anne, can you share your examples of family and individuals who've been struggling to get their stolen art returned? And do you want the presentation up, yeah? Could you put, it's there, okay, thank you.
Thanks very much. So I'm also going to start, we'll continue actually to do with looted art in the Czech Republic. The Czech Republic is one of the few countries with a restitution law that was enacted in 2000. And here are 5 out of 135 drawings that were returned in 2003 by the Moravian Gallery in Brno to the grandson of the owner as the result of the law. But here are 2 other artworks, also in the Moravian Gallery in Brno, which belong to the family of Adele Kulka. And here are 8 of some 80 paintings that are in the National Gallery in Prague, which belong to the Richard Popper collection. And here they are published in an excellent comprehensive book in 2019 by the Czech Documentation Center. The Czech restitution law says that only direct descendants can claim. And the cases that I've just showed you, the Kulka case and the Popper case, the immediate family was murdered. Their legal heirs, nieces and nephews, decreed by the Czech courts to be their heirs after the war, are barred from claiming and therefore from restitution. For artworks found outside the Czech Republic, they can claim. I should add that the Czech restitution law is not consistent with the Czech Civil Code, where normal rules of inheritance apply. Now let me move on to Italy, a country like others that requires a law to enable restitution, but hasn't created one, though it agreed to do so 16 years ago. Here's a painting by Moretto in a museum in Abano Terme near Padua that belonged to Julius Priester of Vienna. And here's a painting by Civerchio in the Brera Museum in Milan that belonged to Federico Giuseppe Gentili of Paris. Both cannot be recovered. Both are agreed by the museums to be looted, though the families have recovered many other paintings in France, the UK, the USA, and elsewhere, but these paintings cannot be returned to them. Let me tell you about Poland. This is a country that that has many looted paintings in its public collections, but will not restitute, though it recovers many paintings taken from its public collections, which are found in other countries, thanks to the restitution commitments of those countries. Here's an example, a looted painting by Alexander Jerimsky in the National Museum of Poznan that belongs to the Holzer family. Poland agrees it's looted but will not return it. On the other hand, here are two looted paintings by Dierik Bautz that belong to the Czartoryski family. They were found by us in a museum in Spain just over 2 years ago, and the family made a claim, but so did the Polish government, claiming them as Polish property because they were taken from the territory of Poland. Although this is contrary to the Washington Principles and the Terezín Declaration, which, as I said, the Polish government uses all the time to recover property taken from Poland. Both these once Polish families, of course they don't live there anymore, have had no problem recovering artworks seized from them that are now in other countries. And finally, just examples of what happens with private foundations in the art trade, and two examples, one from Germany and one from Austria. They're all looted paintings from the collection of Bruno Jelinek of Vienna. And here are two of them, which are in the Tansy Foundation collection at the publicly owned Bowman Museum in Celle in Germany. And here are four, which are today with an art dealer in Vienna. The Jelinek family has recovered many works in many countries, including Germany and Austria, and even from auction houses in Vienna. But none of these 6 paintings can be or will be recovered. Legally, neither the art trade nor private foundations have any obligation to return, and in both the cases shown here, they refuse to do so. So unless the law is changed, whether in Germany or elsewhere, or the Austrian government takes up a proactive position with the art trade, nothing can be done to enable the return of these paintings.
Thank you, Ferdinand.
Thank you. I understand I have to say something about immovable property, and there we have to make a difference between the 3 categories: private, communal, and heirless property. Of course, where people feel personally concerned is private property, and there it's this feeling of injustice that happened for the second time after the war to the families who did not have the means or did not have not been in a position to pay an expensive lawyer or something in order to be well represented in order to get their property back. It was easier for a family like Rothschild to get at least certain elements back, but on the other hand, they also faced for instance, a practice of allowing only export of certain artworks when they in turn made a gift to the museums in order to be left there. So they lost property in order to be able to export their property abroad, and they lived abroad in the meantime because they had to flee the Nazis. So this is how people felt in the field of communal and heirless property. Of course, the situation is different, but nevertheless, there was grave injustice happening after the war, and this is very often forgotten. And after the war, under the influence of renewed nationalism of the former victims of Nazis, but also under the early rise of communism. So those countries who tried to regain their national identity at the same time, they faced communist interference, and it took another how many years until '89, until finally this problem was a way in order to tackle the injustice after the war. So this long time past is actually not a long time past. It's actually we had to start anew, and this I think is a very important aspect when we deal with restitution today.
Thank you. Could I invite David to contribute? Do you want your...
Yes, in just One second. Thank you, Lord Pickles. About this question about the links to the families, you've mentioned also with the history of Mr. Wiener. I would like to stress the fact that there is really a connection between the object, the artwork, when it is returned to the families, and the family today, and the people, the heirs, when they receive it. It's not a question of financial value, and we see each day when we work with the families, and when the Commission recommends a restitution, when we do the restitution, there is really something which is going through the object from the families, from the owners during the war, to the family, to the heirs today. And I think it was really interesting to see Mr. Wiener and his grandson today, because I think I would like to underline the fact that we really work today with grandchildren, great-grandchildren of the owners, of the spoliated people. Some people who come sometimes knowing what happened, like Mr. Wiener's family, but sometimes without any practical, without knowing what happened. They are looking for information. They are looking also for recognition by the state, by different states of what happened, and they are really seeking for information. And we try to bring this information to them, and I think it's also important because very often we are asked, how long are you going to do this work, till when you are going to return or to try to return objects. Maybe you should stop maybe soon. And we see with these families, with these great-grandchildren, people age 30, 35, 40 now, that there is really a connection. And for example, I just would like to say a few words about this restitution last year. So you can see we don't have any Klimt left now, and it's not just a question of paintings and of important financial value, but also sometimes we can return. It was the first time an object, a ritual object. It's a bag for tefillin, phylacteries, which was deposited by the GERSO, Jewish Restitution Successor Organization, after the war in the first Jewish museum in Paris, and deposited to the Museum for Jewish Art and History in Paris. And it was returned last year to the family, to the great-grandson and great-granddaughter of Élie Léon Lévy-Valencin, whom you can see on the left corner up, and you can see also the son, Georges Lévy-Valencin, robbed in Paris during the war. And this very simple object was really a symbol for the family, and especially for the great-granddaughter Milena Katowski-Ayash, who received it as really a gift from her great-grandfather, and it really brings all the history of this family, and she keeps the bags with her, and the ceremonies was really a particular moving moment with the Minister of Culture, Mrs. Bachelot. So just to underline the importance and of what is also in the restitution, and no matter the value of the objects, financial value.
I'd like to link this question to this issue of where history has not been studied. Romania is a country which has done nothing in regard to the return of, or the investigation of, the history of the looting of cultural property. It may be beginning, but the archives are not open, and this is something which is simply not known. Imagine for a moment that you are in a family that does not know anything about its history, does not see anything from its history. It's a blank. Other countries have begun to do things in this regard. Croatia in the last few years has actually done a certain amount of provenance research on what was taken and where those objects are and something about the collectors and the like. So for example, one of the collections that was researched was the Macelski collection, which was fairly extensive, and the granddaughter, step-granddaughter of Robert Deutsch Macelski and his wife found out about this. She lives in the United States now. She found out about this. She didn't know anything about it. She had some vague notion. But when she saw the articles and the photographs of things such as a painting by her, of her mother, her stepmother in this case, she, of course, started crying because it's the only connection. Actually, I have to say that Dr. Stopes was talking about his family yesterday. It's quite obvious that this is a major matter. But I want to point out something. We keep talking about the meaning of this to the victims and the victim families. But I think we need to talk a bit about the meaning to the grandchildren of the perpetrators. You have a problem that there has been no fascistization, there's been a denazification in Germany, but you don't have the fascistication, if that's the word, for countries that had, were allies of Hitler and that had some of these same things. There's meaning there, and I think that we need to take a look at the effect of making much of this history known. Beyond this, I think that we would be talking about the fact that when this may be, this very often is the only connection that a family has to its history that is physical. And it really has tremendous meaning from that standpoint. But that's on the victim side.
Thank you. Pierre, could I ask you to just go?
I would like to just relate on what you just were talking about, family, because provenance research is, it's, of course, we have to meet our law, to establish all the facts so that the board can decide and the minister can decide. But of course, we are finding the stories of families that have been forgotten, that have been destroyed. So this is what makes it such an interesting and important and also emotional task for all of us working in this field. And when you were talking about working together with the families and the heirs, I wanted to tell you a little story that just came to my mind. That I had the pleasure of attending a birthday party some months ago, a birthday party of a person who got 103 years old, and the party was celebrated via Zoom because this man was living in Illinois. He was a survivor of the Holocaust, but not only that, but also an heir of another of his uncle, who was a collector of a vast collection of different things, not very valuable, not very expensive things, but little drawings, pieces of folkloristic art, and also antiques. And in Austria, we started to restitute or to recommend the restitution of pieces of this collector's collections in 2001. The last decision was in 2018, I think. You would maybe wonder why so many decisions on the same collection. It's very clear, and it happens very often, that there is not only a diaspora of people, but also a diaspora of collections and things. So it took many years to find all the different things, but only, of course, fragments of this originally a much bigger collection. So we met because it was the last thing for the moment, object that we found of this collection. And so we wrote, or our State Secretary of Arts and Culture wrote a letter to this heir, telling him that now this restitution can be conducted eventually, and telling him, and she said to him sorry for what happened to him and to his family. And so we sent this letter to this man. And his son, who was also not, again, the youngest one, called me and invited me not to just send this letter to his father, but to read it to him, because it's his birthday. So this is what we did. We had this Zoom party, and then I started to read this letter, and this man, he started to cry while I was reading, and his son was explaining that after his 98th birthday, his father, who was not too emotional in his former life, started to get more and more emotional. So it was an emotional moment for all of us. Everyone was crying. And this man said to us, this is the sentence he was waiting for his whole life. And the saying that we are sorry as a country, as an Austrian republic, and this is the most important thing about doing this art restitution initiative. It's what I said before, it's the symbolic act, it's only the symbolic act. Yeah.
Thank you, that's a very moving story, very moving story. David, what do you think we could do to improve cooperation on provenance research and best practice?
Very important question. There are a lot of efforts in different countries. First, in between public committees, public organizations, our fellow colleagues here in Austria, and we have a working group of different committees with the United Kingdom, Netherlands, Austria, Germany, and France. We try to exchange good practices, I think best practices. I think we could do really better. Always the same problem is to do the same research at the same time, or not at the same time. It's just we go and see the same archives without communicating and without exchanging our work. That's a problem. We try to do better and to use all the information already known by colleagues, but it's not so easy. But we try. We have there are a lot of provenance researchers now, especially in Germany and in Austria, more than everywhere else and more than in France. They have, for example, a very important association of provenance researchers in France and in Austria, with for us a small group of researchers specialized in about France and the art market in France during the war. So we know that we can also ask a question to our colleagues, and step by step, it's the relations are better, and we can have answers from our colleagues. I think I repeat one thing about the art market. We could work more with the art market, with the auction houses, with the art dealers. Our goals, of course, are not the same. We are asked by some art dealers or auction houses who wants to have like a green light from us. That's not our job to certify the provenance of the objects, but we can have we can share information, because of course they need us, and we need them to know the history of the provenance of artworks, who was the seller before the war or after the war, who was the buyer. So we have a lot to do, but each day we can have a new progress, but we know that there are really a lot to do, still a lot to do with the market and between researcher, between private researcher also and public researcher, and we need more public researcher, of course, in our museums and administration.
And your that slideshow was really actually so revealing. You know, given there are so many obstacles, both in terms of procedural obstructions and laws to make it difficult. I mean, if we're serious about this, what needs to be done to make things just a little bit more straightforward?
Yes, thank you. I mean, what I didn't say, of course, is that the families find the whole situation completely incomprehensible. They find it distressing beyond belief, because often the nephews and nieces are, you know, say the Czech Republic, the nephews and nieces are the only survivors of the families. And these, as David talked about and Pia talked about, these things matter a great deal to them. They're the last links with families. They've heard about these people, and they have who were murdered, you know, with the Richard Popper, he and his wife and his daughter and his granddaughter were murdered. So the families want that connection, and they don't understand why the situation is as it is. They say there are all these conferences, you know, people come together, they talk about it, but nothing seems to change. What can we do about that? Well, I think there are two things that we should look at. I mean, one is this. It's a bit like David was talking about with the Provenance research, but we need to have networks. First of all, we need to have implementation processes, but we also need to have networks. What we have, and I'm very proud to have co-authored this, was the Spoliation Action Plan, which was of 2017, which was adopted by 5 countries, the 5 countries that have claims processes. So it was adopted by the UK, France, Germany, the Netherlands, and Austria in 2018. And and it has a comprehensive series of proposals which were agreed to do. Now, in relation to restitution, Lord Pickles, one of the key recommendations, one of the key agreements that the 5 panels have agreed to do, and they have, obviously between them, they have a lot of expertise and knowledge. One of the things that they have agreed to do is to provide and publish a written framework of best practice and guidelines for claims to both public and private collections for all countries which don't have a formal process, and so they can look to that for guidance. I think there is a key issue here that in those countries which don't have any process at all, the wheel doesn't have to be reinvented. The 5 countries can provide, the 5 panels can provide the guidance, they can provide best practice, they can provide the definitions, they can provide something which is an equal process that every country could adopt, because it's a neutral guide to best practice. And I think that in itself would be a hugely important step to be taken.
Thank you. We've seen examples today of art that was looted in one country and is now in another place. How best can we deal with problems like that?
Well, first of all, I'd like to note that some of that is it's cultural property that belonged to communities. So, for example, a major example is if you ask the question, where is the Judaica of the Greek Jews? The answer is Warsaw. And the problems there are quite major. It seems to me that in that sort of case, the answer would be in 2 things. One is challenging the morality of a country that essentially tries to receive things that were taken from it, but does not return things that were taken from other countries, and which really bear nothing in common with its own culture. It's just simply an anomaly of how the war ended. The other part of that is that this is a cross-border question, and there the European Union could play a major role without too much difficulty. There has been enough interest in cross-border matters that the European Union could indeed take that up in a better way. Beyond this, this becomes a question of, if there are individual cases, this becomes a question of the laws in the various countries as to whether or not something which is in another country can be dealt with this way. My feeling is that this is something which, more than anything else, has to be a discussion about morality and dealing with this country by country.
That's very helpful, colleagues. You've been so patient and so very attentive. I haven't seen anybody checking their emails, which I think is a good sign. And you missed all that. I was being nice about you. I just wonder, are there questions from the floor? We've got about 5 minutes. Anybody would like to ask a question at all?
This was, again, an extraordinary panel, and I think, Lord Pickles, you've done a great job of organizing it. I guess what I would like to know is, we have the Washington Principles as expanded slightly by the Terezín Declaration. Are there specific additions to the principles themselves that would help? And Anne, you mentioned this 2018 agreement. Are the best practices now well enough publicized and established? So, what is there a next step to the Washington Principles that we could even circulate to some of the countries? And here are improvements, updating based on the results of the last 15 to 20 years. I'd like.
Sorry. I think a lot of people would think that was an excellent idea, because I think obviously the situation has changed. People have learned a lot in the last 24 years since Washington. The Terezín Declaration went some way to specify particular categories of loss and so on. But I think that for these particular situations that arise, I think it would be very helpful if we could expand them a little or refine them a little. And I think it would also be as a practical guide for countries. As I say, one could include best practice guidelines, for example. One could include what definitions of loss are. One could include something about what, after the war, it was completely understood that one must presume that loss was involuntary. That has got lost today. I think we could have guidelines even for where we have laws, like here in the Czech Republic, or where Italy doesn't have it, laws how to create the possibility of restitution. So how to change the law, which laws need to be changed or which laws need to be created. I think that a practical guide or an addition to the Washington Principles would be welcomed by a lot of people, because it would have the authority that nothing else would have.
Does any of the panel want to briefly make a contribution?
May I say that I think that some of this has to do with definitions. And you may know that Anna Rubin and the Holocaust Claims Processing Office in the United States has wanted to have a conference on definitions. There are also the project of Matthias Weller, who is here in regard to some of these aspects as well. But there are certain things that have come up which have not been discussed really up until now. So the issue of Fluchtgut, the issue of flight goods, for example, is something which is not in the Washington Principles, nor is it in the Terezín Declaration. It is the kind of thing that needs to be, it's the question of definitions of loss and what that would mean. There are other sorts of definitions that are not entirely clear in the Terezín Declaration that perhaps should be indeed made stronger or more specific.
Ferdinand.
Thank you very much. Just shortly, I think as we see, there is so much practice and so much experience and so much best practice around that really one should find a format to keep a certain dynamics of exchange of information, but also a common action. And I think the idea with Holocaust representatives establishing that network seems to be quite convincing.
You may remember when you were bouncing on your mother's knee that she told you that all good things would eventually come to an end. They just have. I'd like to, on your behalf, to thank the panel. I think it's been an extraordinarily interesting discussion, and I think it's been a real feeling that, you know, we shouldn't really rest on our laurels, that we shouldn't feel too content, that the best way to make progress is by moving forward, being perhaps a little angry, and to try and get something sorted out for the people, not for the objects, for the people. Thank you very much. It's been an honor and a pleasure to chair you. Coffee awaits.